Welcome to the Trends in Motion Picture and Television Financial Litigation. My name is Ilan Haimoff. I'm a partner and entertainment practice leader at the accounting firm of GHJ, where I focus on film and television, profit participation, audits, and forensics. I am pleased and honored to moderate today's panel. Today's program is sponsored by the Entertainment Law Section. The Entertainment Law Section itself is sponsored by the Lawyers Mutual Insurance Company. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of area of practice, including entertainment law. Learn more at lawyersmutual.com. And with that, I'm delighted to introduce our speakers. We have with us today Ashley Jurgen, partner and co-chair of the Entertainment and Media Group at Russ, August, and Cabot. We also have Bobby Schwartz, partner and co-chair of the Media Entertainment Industry Practice at Quinn Emanuel's Los Angeles office. And last but not least, we have Chad Fitzgerald, partner with focus on entertainment litigation at the Kinsella Law Firm. Welcome.
Thank you for having us, Alon.
Thank you.
It's my honor. And really quickly, from a logistical perspective, we have lots and lots of people joining today. If you do have any questions, please, as in the past has been done, please put those questions in the Q&A box, and if time permits, we'll consider them. However, we only have an hour, and if we are unable to respond to them, we've asked the Beverly Hills Bar Association to send those to us, and then we'll do our best to get back to you via email. So with that, let's get into it. All right. The first area we wanted to cover today is general industry trends. So we're going to kind of start at the higher level. And what I wanted the panel to cover first is let's just talk about what trends each of us see in terms of type, significance, and appetite for litigation. And we're going to go in the following order. We're going to have Bobby start, Chad will follow, and then Ashley will close. And again, what trends do you see in terms of, type, significance, appetite for litigation right now?
Right. And obviously, we're confining this to litigation pertaining to financial arrangements, participations, investments, back ends, the thing that, and not all the other kinds of disputes that we all get involved in. And I was joking. I think that the pithy comment is the more things change, the more they stay the same. The driver in a lot of disputes now is something that's been happening for 25 plus years, something that Larry Stein coined 25, actually more than 25 years ago, vertical integration with challenging related party transactions within a vertically integrated company. And he was suing at the time Fox, which was, the allegation was they were licensing MASH, X-Files, and other content to their affiliate, the FX cable, basic cable service, below market. And it was depriving the participants of money to which they were entitled. The result of that was a wave of contract provisions that dealt with how and the terms and the basis on which a studio could deal with licensed content to an affiliate, and there would be benchmarks. And over time, those benchmarks have become more and more favorable to the studios. Nonetheless, we are still seeing a lot of litigation. I mean, we go back to COVID. Warner Brothers, then owned by AT&T, announced Project Popcorn. Jason Kilar took a lot of heat for that. The notion was that in the following year, that would be calendar year 2022, I think, all of the Warner Brothers theatrical releases would debut day and date on HBO Max, because there was a lot of pressure to drive viewers to HBO Max. And I represented a lot of clients that had theatrical deals with Warner Brothers who were not happy about that, particularly not just because it was undermining the theatrical revenue source, but it wasn't being made up on the license fees that the affiliate was paying. And I think at the time, some Warner took the position that, well, we're really sorry, but it turns out our output deal with HBO doesn't obligate them to pay additional monies for streaming the content because they obtained streaming rights under the original output deal with the linear channel. And so that's what it is. So that has not stopped. And at least I'm seeing situations where to build the audience or to make the economics of the affiliated distribution entity, which at this point is a streaming service, look better. The content acquisition costs are depressed or suppressed by paying less than what the studio would get from an independent streaming entity. So just to dig into this a little bit deeper, I've seen situations where a studio or a TV network would create content with a client, co-finance, co-produce television series. And for a non-exclusive license to a Netflix or an Amazon or a Hulu, they might get $30,000 to $50,000 an episode. The same episode of the same season was being made available on the affiliated streaming service at the same time, and we discovered that the payment was around $800 an episode. Very hard to justify that, and so I spend a fair amount of my time dealing with these situations, and I think there is less and less of a resistance on the part of the potential plaintiff to file a lawsuit. And we'll get into that a little bit later. I don't want to monopolize this, but let me stop and tell you that's what I'm seeing.
I think, Chad, you're going to go next.
Okay, thank you, Lon. Yeah, I have to echo everything that Bobby said. I mean, I'm primarily a talent litigator. I represent, everything from individuals to smaller production companies against the studios. I do a lot of profit participation audits. And like Bobby said, what is old is new again. It's the same thing we were dealing with in the inception of this vertical integration kind of litigation. The only difference is that now, instead of questioning the value of a license in syndication to a terrestrial cable network or internationally, now the bulk of the money that the audits turn up is on streaming. Of course, streaming has changed and sort of upended the industry. But upended is probably the wrong word because it's the exact same claims, like Bobby just said. It's, instead of selling the show to your affiliated cable network in Germany or on basic cable in the US, there is licensing it for below market costs to their affiliated streaming platform. And the streaming wars they seem to be kind of over or nearing an end now, but for a while, a few years ago, up to 10 years ago to more recently, every major studio, with a couple notable exceptions, was in this arms race to establish their own in-house streaming service. And that is just a recipe for the price depression, suppression that Bobby was talking about when they license their own content to their own streaming platform. So it's just a new vehicle, a new package for the same old problem. And I'm seeing, I agree with Bobby that there's certainly a less of a resistance for my clients to at least do an audit, right? To see if the show has made money, it's worth, however much a firm like yours would charge to do the audit. The audits often or almost always are going to uncover some money, some potential shady accounting or whatever. And then it's also usually, I mean, I don't have a lot of cases that are going all the way to filing a complaint, but I certainly threaten that. And ideally, we negotiate a resolution, but litigators are a part of that negotiation. And the only other thing I would add on what Bobby said is that, in the way that studios got smarter and smarter with these benchmarks, these affiliated transaction provisions that they would put into their contracts to say, oh, it's okay that we do this as long as we meet some sort of nebulous standard. They also got very smart about putting mandatory arbitration clauses in there. So, I mean, the amount of court cases I get to file is very, very tiny compared to it's all in arbitration, and therefore it's confidential, and we can talk about generalities but not specifics unless it's in court.
I think Bobby and Chad pretty much covered everything that I'm seeing. I would just say that even preparing for this panel in terms of pulling materials was difficult for the reason that Chad just articulated, which is that most, if not all of these cases right now are in arbitration. There are a few over big, huge issues that we've seen that impact participants, like the Scarlett Johansson filing on the Black Widow thing a couple of years ago, the Village Roadshow WB started in court. So we sort of saw what some of those allegations were, which included an allegation about day and date exploitation of the Matrix when it should have been theatrical only. And then you kind of had the CBS Sony fight over distribution and participation on those big series of Jeopardy and Wheel of Fortune. For the most part, though, everything else is sort of hidden, which is why it's important for these kinds of panels to happen so that we can kind of talk about what we're seeing in generalities to know what the claims are and what we should be looking out for.
Elon, can I add something to what they were
Yeah.
talking about? So I think arbitration, I mean, that is a fixture in virtually every contract I see now. And it may be 90% plus. So that's whatever that translates to rhetorically. And I think the impetus for that was a desire to take these fights out of the public arena and avoid the press chiming in about what horrible people the studios are or whatever. And the assumption was there'd be less adverse PR, it'd be faster and cheaper, and you could better contain the possibility of a runaway outcome. I think that hasn't, I mean, maybe it has in some respects, but I think it has also caused disputes that might be on the bubble to be litigated, where people would say, hey, you know what? No one else is going to know about this. Other companies that might hire me or that I might do deals with to co-finance things won't know. Maybe that's wishful thinking, but I think there probably are more of these cases litigated because of arbitration provisions. And I'm not sure, frankly, that they're faster or cheaper. And as Fox found out in the Bones case, I don't know that there's insulation against getting hammered. I mean, obviously, when that arbitration ruling came before the Superior Court judge, he tossed out the punitive damage portion of it, but the underlying actual damage award was massive. So anyway, so arbitration, mixed bag. And the other thing is, I've encountered a lot of people who, yeah, they know their client is subject to an arbitration provision, but they want to make a public statement, and so they'll file a lawsuit anyway, knowing that you're going to move to compel arbitration, and just sort of look sheepishly and whatever. But they got their shiv in your back with the PR they wanted.
Thank you for that. Yeah, Bobby, I appreciate it. And thanks for the overview from everyone. So what I want to do now is obviously the big transaction that everybody is thinking about is the pending sale of Warner Brothers, or at least a portion of Warner Brothers, to Netflix, and the ongoing battle between Paramount and Netflix in pursuit of those assets. There is so much that will go on over the next maybe 2 years before we'll see who the ultimate buyer and how the transaction would look like. What for the purpose of our webinar, though, and again, it's very difficult to predict, but wanted to see if you can comment on the potential impact of a significant transaction like this on the potential of litigation risk. And again, it could be a general comment or it could be more specific, but just hearing from you as to your thoughts as to how this transaction could potentially affect future litigation. And what I wanted to do here, sorry, just to be more specific, Bobby, if you don't mind, maybe be the first to kick it off
Okay.
and then see if Chad and Ashley have any
I'm
additional.
happy to defer to them and then fill in. I don't want to be doing too much talking here. So why don't we let unless
That's fine.
whatever they want to do. Ashley, do you want to
Sure. I mean, I think it's going to be interesting to see we assume Netflix is the one that takes all. Are they going to import the Netflix model on future WB, property, or are they going to let WB continue the way that it's been? If it is the Netflix model, then over time you're going to see probably no back end in some of these deals, which will obviously lead to fewer profit participation cases, although they will be assuming a library that will have participations, that go on for a period of time. So that's kind of one question. I think the theatrical, non-theatrical aspect of it is a really interesting one. Ted has clarified his position on that recently. And I think people that are in production now on Warner's projects may have commitments that their project is going to be released on 5,000 screens or what have you. So one would hope as a participant or talent lawyer that those are going to be honored when Netflix comes to be the distributor of those works. If not, I think you'll see a lot of claims specifically arising in that area.
Yeah, I mean, that's exactly what I was going to say, and I just want to add on to it that the talent community that at least that I've heard from the talent reps and also talent themselves are kind of justly freaking out about this because there's really no good outcome, or there are problems with either outcome, whether Netflix ends up owning Warner Brothers or Paramount does. If Netflix ends up owning them, it's everything that Ashley was just saying. It's the fear that backend will go away, that theatrical release windows will shrink to nothing. Um, but conversely, it's not a bed of roses if Warner Brothers ends up, I mean, if Paramount ends up buying Warner Brothers, because then there's one less major studio, there's one less buyer for content out there, and how that affects negotiation, pricing. I mean, from my vantage point, selfishly, if Paramount ended up becoming the owner, Paramount is a studio. They know how to do back end deals. They know how to put movies in theaters. So that might be great for my ongoing litigation work, but the fact that it's just more consolidation, instead of a tech company, which Netflix essentially is, coming and buying a studio, it's another studio coming and buying a legacy studio. So there's one less buyer in the market. Um, I have friends who work at Warner Brothers who will, remain nameless, but they're sort of looking at it from like they might have a better chance of keeping their job longer if Netflix comes in, as opposed to a studio which will have redundancies and have legal departments and business affairs departments. There may be massive layoffs. So it's really not great on either side, from what I'm hearing.
Uh-oh, it's going to be unanimous. The I when Netflix announced the bid, I'm not alone in having the reaction I had, which was why do they want Warner Brothers? Why do they think they need Warner Brothers? Are they buying it to keep it away from other competitors? How big of a competitor was Paramount at that point anyway? Did it matter? What do they really want? I don't think they bought Warner Brothers or hope to buy Warner Brothers because they like being in the exact same business that Warner Brothers is currently in. I mean, that's a roller coaster ride. So you have to assume they bought Warner Brothers. At least I'm making the assumption they bought Warner Brothers to keep HBO Max from eating too far into their market share, and because they view Warner Brothers, especially the TV unit, but also the feature film unit, as a pipeline for content and a whole group of people that have creative relationships and so on and so forth, and a great library that they can maximize. But it is not to maintain the status quo of Warner Brothers. And the status quo of Warner Brothers, at least historically, depended a lot on a theatrical release window. So there's got to be, you have to assume there are going to be big changes there. Will Netflix, if they are the winner, honor contracts? I think they're not going to set out to just wholesale breach agreements. I think they've built into their models that there will be a period of time in which they have to honor certain obligations, like Ashley was talking about, for theatrical release commitments. But that phase will last as long as it has to last, and then uh, Warner Brothers will be a different proposition than it is today. And if you and it's going to lead to more disputes. And I think with Ashley, I think you had a very good point about legacy content where there are ongoing obligations, and there may be content that isn't subject to agreements that have affiliate provisions.
Mhm.
And we saw a wave of class action lawsuits a couple of years ago involving older movies where classes were formed against each of the studios for distributing movies that predated home video provisions and royalty provisions, and said, "What are you doing? I never agreed to a royalty." Those got settled, and quaintly, they dealt also with EST, which nobody really thinks about as a form of distribution now. So anyway, that's going to happen, and it's going to have to just work its way through the system like a rodent through a python. If Paramount wins, I don't see it being that different. I mean, I again, I don't think Ellison is looking for scale. I think he's looking for content and wants to have a preeminent streaming platform. So, he may be a newer entrant, but the consolidation and the emphasis on streaming is inevitably going to change deal making opportunities and drive more disputes.
Everybody, all of your comments are appreciated, and I would agree with all the comments. I was just going to add that emphasizing something that I think both Ashley and Bobby mentioned, more specifically, and it's a question: will the ultimates potentially shrink in the future for existing IP that is being distributed by Warner? And with the combination of related parties coming together, I think there is that risk of valuation. There's that risk of arm's length transactions and the ensuring that the valuation is reasonable. So there's, I'm sure, more to come. Again, it's all hypothetical. We're all watching and seeing where we're going, and more, I'm sure we'll hear about in the coming year. All right, so we're going to jump into our next major area, which is just focusing on litigation in the area of contingent compensation. Here, I wanted you, Chad, to maybe kick it off. And again, this ties into what Ashley says. We rarely ever hear about those cases because they are subject to confidentiality within, obviously, the confines of an arbitration process. So we're going to talk this in general, but I do want to see if we can dive into the kinds of issues that we're dealing with right now in connection with contingent comp. So we'll have Chad maybe kick it off, and then Ashley and Bobby to add, obviously, as well.
Yeah, well, I was noticing, and I'm not trying to jump ahead to the Q&A portion, but Greg Raymer had a good question about
Yeah.
imputed license fees and those making sort of becoming a thing again, as he said, and making a comeback. And I am seeing that not so much in litigation as in sort of pre-litigation negotiating deals, negotiating settlements, but imputed license fee, just very briefly, for anyone on this panel who doesn't know, or not on the panel, on the audience who doesn't know, is when there's a related party transaction and a check doesn't actually have to be cut and money moved from one arm of the company to the other, but they will literally impute sort of a bookkeeping entry for the value of the license of the transaction. It's an internal bookkeeping mechanism that actually does ascribe value for a license to the license fee, and therefore that value filters down hopefully to the participants. That was a big deal a few years ago. There was the Walking Dead litigation that I was involved in, the first Walking Dead litigation with Frank Darabont and CAA against AMC. There was an imputed license fee in that, and we argued for many years over whether that was fair market value or approximated the contractual affiliate transaction language. Studios and content creators seem to have gotten away from imputed license fees a little bit after that, and actually would try to ascribe and pay an actual license fee in some, I mean, I would argue as a talent lawyer to make it look more above board. But it's the same issues. Whether it's real money or imputed money, it's still, is it enough money? But now in the streaming context, I'm seeing studios that have their own streamers. Again, they will remain nameless, trying to put in imputed license fees into their deals for when they sell the content to their own streaming platform. Um, and so the same, like Bobby was saying at the very beginning, what goes around comes around. It's the same old thing. And deal lawyers have to be particularly cognizant of that and pay close attention to it, because at least the ones I've seen trying to be put into, overall deals, renegotiations of overall deals, these sort of established relationships, the studios are now saying, oh, by the way, we have a streamer, and if we're going to sell your show or all the next shows you make to our streamer, and by the way, here's what we're going to impute a license fee, and it's too low, it's not market rate, it's not what an unaffiliated Netflix or Amazon would pay. So it's moving that discussion up to the deal making phase, but I have no reason to believe that the studios are going to up their imputed license fee. So then in the deal making phase, so then it will eventually, sooner rather than later, filter down to litigators like us, and we'll have to argue that, yes, here's the imputed license fee. Yes, we signed the deal, but it still doesn't, and if we can make those arguments, it still doesn't comply with company's good faith and fair dealing. It doesn't comply with these other obligations elsewhere in the contract to make all transactions substantially equivalent to an arm's length basis, or whatever the wording is. So it is coming around again. It is coming back into the fore, I think.
Yeah, um, I think this highlights an asymmetry in the warfare between a distributor slash studio on the one hand and a co-financer, co-producer, or talent on the other hand, which is if you have an imputed license fee that is a dollar amount, that's one thing. If you have an imputed license fee that's based on a formula or a concept, that's a recipe for a lot of mischief. Often there would be ones that you talk about fair market value, but that's not a popular concept. And so you get wording that's like, what it sort of gets inverted. Either what the studio is receiving for comparable content that it licenses to an unaffiliated entity, or what call it in this way, the streaming entity is paying to acquire comparable content from an unaffiliated licensor. And that actually, those are very different standards in practice. And let's acknowledge at this point in the deal, like the talent is usually so happy to have a deal. They don't want to risk cratering the deal over the definition of the back end, much less the imputed license fee for affiliated transactions. And so, a lot of things just kind of get swept under the rug, and people just don't have the leverage or the inclination to try and focus on the language. But when you end up getting a dispute over this, where there's enough at stake to hire lawyers to present and even litigate the case, and you're stuck with this language, then you try and litigate it and you say, well, I want some discovery here. I want to see what deals you did and you realize, well, these definitions or these principles don't apply very well in practice. It's like, well, there are no other deals to look at. I have no other contracts I can give you. Sorry. And since you're the
What is
plaintiff,
comparable content? Like
yeah,
how
like
do
what
you
does that
really
mean?
compare these kinds of shows to each other?
Yeah. And
A lot of
so
studios are comparable content is what we say it is.
yeah, and you may have very limited discovery rights. You may be in an arbitration subject to provisions where your right to any discovery like this is going to be up to the good graces of the arbitrator and whether they think you've shown good cause, or maybe it's further constrained by the rules. And nobody, I'm not saying anybody's not doing their job. It's just at the time you're negotiating the contract, you don't, this isn't where you're focusing your energy. You're focusing your energy, especially if you're doing a deal directly with a streamer. It's like, look, I have the back end, come on, what's it really ever going to be worth? And so Elon, when you're doing an audit and you want to get access to some of these things to check these things, and the door gets slammed in your face, you have no recourse. And often historically, we would have conversations where we'd say, "Don't worry about it. When we file a lawsuit, we'll have discovery, and the judge isn't going to let them get away with this." Well, no, because you're now in an arbitration, and you may have different discovery rules, and so you may never be able to prove your case. You may never be able to adduce evidence that would benchmark or provide benchmarks for what these fees are to deal with the fact that the party on the other side is doing deals with its affiliate. So it's a serious problem, and that doesn't lend itself to an obvious solution, but people should have their eyes open when they're negotiating these deals, as to how they're going to be enforced, if they're going to be enforced.
Well said. No, I appreciate it. I think this is a topic that I think we'll be monitoring over time, and it has to do with what information do we have to value the distribution, the value of the licensing. I think or challenge the imputed license fee. I think the Chad, I think, kicked off the conversation with. We as a as a firm, we try our best to keep ourselves aware of trends, try and maintain key performance indicators and work with our clients to try and assess the reasonableness of those valuations. But I think it's an area that will stay with us for some time. So let's move forward. I actually wanted to jump to an area that is something that is at the forefront of our business, which is artificial intelligence. I actually want to get into that topic next. And the one particular deal that I hope, Bobby, you can talk a little bit about is the Disney OpenAI investment deal that is publicly available. Everybody knows in general, we don't have all the details, but that deal was struck not that long ago. And OpenAI is having I think, other discussions with other IP owners. But before we get into that, I wanted to see if maybe, Ashley, you can kick off the conversation about the types of AI related disputes we're seeing right now. Um, and then I'm going to see, Chad, maybe you can add if you're seeing as well, but then I wanted, maybe Bobby, you'll be the last to get into that Disney AI investment with OpenAI. So Ashley, maybe you get that
Yeah.
conversation going.
So I think we're seeing kind of three lines of cases, or how I would describe them. There's the input cases, the output cases, and then kind of what individual talent are doing to protect their name and likeness from AI infringement and deepfakes. The input cases are looking at what content is being used and how is it being copied and stored to train AI models. The early cases in that area were not particular to the entertainment industry. The first ruling that came down was actually a Thomson Reuters decision that had to do with Westlaw headnotes and a company that was trying to create a direct competitor to Westlaw. That decision actually rejected a fair use defense on the grounds. I think that was heavily driven by the fact that the defendant was trying to create a competitive tool to Westlaw that was basically a mirror image of that. The other two cases that have come down came out the opposite way. So you have Bartz versus Anthropic and Kadri versus Meta, and those both found fair use. So it basically said if you're scanning books to train the AI, and the AI's output is not going to be substantially similar, because keep in mind what we're worried about here is copyright infringement. Does the product of whatever you're doing look substantially similar to what the input was? So if you're just scanning books to train an AI model, then the AI model is just learning language. Whatever it outputs is not going to be substantially similar to someone's novel. So I think that's what really influenced the courts there. Interestingly, in Bart's, though, the court actually said that storing all of the pirated content on the database for the purposes of training is not a fair use. So they got caught there. So people are going to have to be careful about how and where they do their copying and where they store things, which will translate as time goes on, obviously, to entertainment works, which we'll get into. And then the output cases are more looking at okay, if you want to create a work that say is Mickey at the beach playing volleyball and you want to give that prompt to something, the output is going to look substantially similar. It is going to be Mickey. And that is what prompted the Midjourney cases. So you had Disney and Universal last year filing for copyright infringement against Midjourney. Warner Brothers filed its own case several months later. The cases have been consolidated, interestingly, set for mediation. They already have a mediator, Judge Suzanne Siegel from the federal bench, with a mediation completion of this summer of 26. And so the question is, are these cases going to go on? I mean, if you look at the complaints, they're very compelling. All of the characters look exactly like Disney characters. You cannot differentiate them. So at the same time that Disney was suing Midjourney, it sent a cease and desist to Google for basically the same conduct on Google Gemini. And then it did a deal with OpenAI, and it said to OpenAI, we'll actually do a license that has some limitations, but of content that Disney fully owns. And so they're starting with that, I think, because then they don't have to deal with the possibility of participants and other people wanting to know where their share is of some of this deal. But you will basically now be able to go on OpenAI and create your own content using Disney characters. And through a bizarre part of the deal, even have the opportunity for your work to then appear on Disney Plus. And I don't know if the economics of that have been worked out and how they intend to pay people. But that is a critical component of the Disney AI, OpenAI deal.
Thank you, Ashley. Chad, I don't know if you wanted to add any comments. I know there's some questions, by the way, about AI, which I want to hold off on. But Chad, anything else you wanted to add?
I mean, I don't have a lot to add to what Ashley said. I
Okay.
mean, in my practice, I'm seeing more of, I think it was her third bucket where it's talent having concerns about, not only fakes, but the use of their name, image, and likeness, their speech, and how they're going to be compensated for that, which is also a very thorny issue. But I haven't delved into sort of the copyright aspects of AI. It's more about talent seeking compensation for their use in AI, and a lot of that is, I mean, I was going to say it's theoretical. It's coming very quickly on the horizon, but it's all sort of like kind of unfocused worldview
That's
right now.
what you just said is actually tying perfectly into what I'm hoping Bobby can speak to, and that's how does that partnership between Disney and OpenAI ultimately affect the co-finance partners and the talent? And we have limited information, so it's hard to gauge this. But Chad, your point is, how do we actually see the value ultimately coming out of these partnerships? So I don't know, Bobby, if
I
you
got
can
to
speak
tell you,
a
it's
little
it's
bit.
strange. Yeah, and
Uh,
there's a fair amount of speculation in this on my part, which I hate because I these are very sophisticated business people, and I have to presume they know very well what they're doing. And I also have to be careful because we represent a lot of AI platforms in IP matters. So, but speaking not for them or for the firm, but just for myself, I'll tell you there's the Disney transaction with OpenAI is strange for a couple of reasons. One, it sounds like it's a tremendous amount of money, $1 billion, and I feel like we're going to do something from Austin Powers, where it's like $1 billion sounds like a lot of money, but to OpenAI, I mean, my God, that I don't, it's not as big as it seems, and yet, a couple thoughts. One, it's strange that OpenAI is not paying Disney for the right to use its content, and maybe there is some aspect of the transaction where they are, but instead Disney is writing a check to OpenAI in return for $1 billion worth of equity. It's not an equity grant from OpenAI, it's a purchase of equity. So what's justifying that? And is this, I mean, a cynical person could look at this and say, well, for one thing, there's no grant of rights to use the Disney IP for training. That's carved out. So what it really is we, Disney, won't sue you, OpenAI, if it turns out that your users are creating outputs that we think are substantially similar in appearance to copyrights, the appearance of copyrighted content we own. But you can't get a leg up in training your model on using our content, even the content that we put in this narrow bucket or smaller bucket and also we're not granting you any name, image, or likeness rights. And so what's the value proposition here? And one thing you could say as well, Disney, it's very important to Disney to enforce its IP rights against AI platforms that are doing things that violate Disney's or infringe Disney's rights. And Disney obviously has every right to do that. But when you look at fair use, which factors prominently in all of these cases, and you look at the fourth fair use factor, which looks at the potential impact or the impact on the potential or actual market for the content, originally everyone was saying like, well, nobody's licensing this to any AI platform. What's the harm to Disney if somebody's using OpenAI to create a 5-second video? I mean, it's like, well, now, no, there is a market now. Disney has done a deal with OpenAI, and this may undermine the value of that transaction or other transactions. And so you could cynically say, no, this is part of a broader litigation strategy to protect the IP by being able to defeat the defense or some of the arguments associated with fair use. Is that what anybody's thinking over there out, on Mickey Way or whatever it is? No idea. But it is certainly possible. And if you assume they're as intelligent as they really are, maybe that's part of it. The other thing is I don't think Disney wants to feel like it's being run over by the tech community. And so this makes them look like, hey, you know what? We're dipping our toe in the water here. We're trying to make sure we stay relevant and we have AI capabilities in our product offerings. And this is a way of doing it for low cost. And so those are some reactions to that transaction. I think there's a lot more to be learned. The other thing again is, okay, well, if you assume Disney's getting some value for this, they're obviously getting value from content that's created by people to whom may have ongoing financial obligations. Is there any obligation on the part of Disney to compensate them or share or some portion of the value Disney's getting for this as gross revenue or gross receipts on those television shows or motion pictures? And we've seen that it happened, was it 20 or 30 years ago when there were competing disc platforms coming out. And I remember, was it Toshiba? Forgetting it. Somebody wrote a check for $100 million to DreamWorks to be the exclusive, so that DreamWorks would release its content only on that type of disc. It wasn't the Sony or I apologize for not recollecting the exact parties
I
and
think it was,
platforms.
I think it was
Was it
Paramount, if I
Divx?
remember correctly.
What's that?
I think it may have been Paramount.
Oh, all right. Whoever it was, but I
Yeah.
remember having conversations with some of your colleagues at the time saying, why isn't some of that money? It's there's the only reason they're paying that money is because they want the DreamWorks animation content or the Paramount, whatever it was. Why shouldn't some of that be apportioned? And so as we see these deals, that issue is going to come back again, as we say, the more things change, et cetera.
Well, and it's going to be hard to parse. There's certain Disney works where the character might be a live human, to Chad's point, where this is an actor. And so, how do you parse the character versus using the actor's likeness or their voice or things like that? And if that person has a participation, shouldn't they then participate in some fashion? I think this initial round, maybe they've limited some of the content so that there's less likelihood of that argument being made. But that is certainly a question. I also kind of wonder how they put guardrails on what types of works are being created, because there's going to be things that are going to be done to Disney content that is not the Disney family brand. And also, what if people have certain rights to create sequels or derivative works of Disney properties, and now they're not the first one to do that because some guy on Midjourney made a sequel to some Disney film. I mean, I don't know how much they're going to be able to do on Midjourney, but to me that seems like a possibility. And then you violated some director's right that they had to make the sequel.
Interesting.
Good point.
Yeah, right now the technology is at least in text to video or image to video, the outputs are pretty short in duration. They usually don't have audio. That's a whole separate process
Right.
to be added on. So, is that, yes, technically speaking, that's the preparation of a derivative work but is it really undermining the market for Zootopia 3? Probably not, but that's for someone else to fight about.
Right.
All right. This is a topic that will also, I think, continue into the future and we'll have to monitor. I think there's a couple of comments I was going to make. OpenAI, I believe, if I'm not mistaken, is looking to go public, and it's becoming a fairly important part of the future of AI, and we'll have to watch and see. The other thing is, what makes it so difficult, I'm sure, as litigators, is it's hard to predict how new technology will ultimately affect the relationships and ultimately have a need for litigation. But this is certainly an area that we'll have to continue to monitor and see. Which leads me to the final question before we take a look at some of the Q&A questions. And I'm going to summarize really, and I call that lessons learned. From your experience, especially in the past year, as you look to the future, what will be the advice, or what would you recommend to a general counsel or a talent or even just transactional attorney to keep in mind for the coming year, um, the potential for litigation areas should they be keeping an eye on as they go through the coming for the rest of this year? So maybe the way we'll do this is, I think, Ashley, if you don't mind, maybe kicking that off, and
Yeah.
then we'll have Chad, and then Bobby will close. Just to get your, what would be your recommendation of what they should be thinking about for the coming year?
Well, I think Chad made a good point about looking at the deals as much as you can and at the deal stage to the extent that you can try to anticipate some of these things that we're seeing and address them if possible at the deal stage. That goes to both what we were talking about on the imputed license fee, but also the issue of name and likeness. SAG certainly addressed the issue as far as what can be done with actors' content that's filmed. But for people that aren't part of SAG, there are ways to build in those protections, and you may just want to do that anyway. I think also just keeping an eye on having your clients do audits. We've had several clients recently that just were resistant to the cost of an audit, and I just think there's too much going on right now that it really does justify the cost of an audit, whether or not you take it to the next step. I mean, among our clients, I think we are seeing some reticence to litigate as both the costs and time of arbitration are increasing. And so if, there is a reticence there, but I do think that the ability to negotiate and threaten it is very important. And so we've been stressing that even if you're not going to go that step and today that you're not going to go to that step, still do the audit, and then see what happens. But I also think the contraction of buyers is going to be something that some of our clients are really going to weigh in terms of whether or not they're actually going to pursue the litigation.
Yeah, I mean, Ashley said it exactly right. I mean, it's funny. What guidance would I give someone who may consider pursuing litigation? Do it. I mean, and not to be glib, but Ashley's point is right. And this is not just a pitch for business because I'm a talent litigator, although it may be also that. But I think people have a misconception that you only need to call or you only should call litigator when you are ready to, at the courthouse steps, file the complaint. And that is, let me disabuse you of that. 90% of what I do and what Ashley does, and maybe a little less, but I'm sure a lot of what Bobby does, is not actually litigating, arguing in front of a judge or an arbitrator in the courtroom. And the amount of audits we see, and I echo Ashley's point, I think I made it earlier, that if you are a participant on a piece of content that has generated some significant amount of money, maybe not even enough to have it go break even into the black, but getting close to it, it makes sense to do the audit. Pay the money, do the audit, because Alon and his colleagues are very good at their job. They are going to find money that you didn't know about. And once you have that audit, I would recommend calling a litigator during that process, because
Agreed.
we are very good, Ashley and I and Bobby are all very good at working with Alon and his team to craft the audit report. So it's, our reports are not pleadings, they're not complaints, but you can say things in a way that will make a potential complaint a lot more airtight and a lot better. And we can help with that process. We can't dig through the numbers and the paper and the receipts the way Alon does, but we can guide that process to a place where, if litigation becomes necessary, or to Ashley's point, before then, if a negotiation with the studio about, hey, this audit report says you owe me $5 million, litigators are, I think, entertainment litigators like us on this call are uniquely situated to help that process. And litigation is not the end goal. In fact, it's to be avoided, I think, because it is very expensive, it is very time consuming, it is a real pain for all parties involved. And the old joke, the only people who get rich off litigation are the litigators, right? But the idea of resolving this dispute short of litigation, whether that's drafting a complaint and saying, hey, if you don't get serious, studio, this is where this is going to go. But even before that, just crafting the arguments, I think that you are well served as a talent or a talent lawyer, to a transactional lawyer, to involve litigators early in that process. I know it sounds like a pitch for business, and so take it with a grain of salt, but I think that we do provide a lot of service short of just arguing and hammering the table in the courtroom.
Here, here. If I were giving advice, I guess you're asking me to give advice. So I think over the next 12 months and even beyond, I'm going to show how facile lawyers and litigators in particular can be by saying, even though I started out saying the more things stay the same, that change, the more they stay the same, I'm going to say, I'm starting to notice some really weird dynamics. And I'll give an example of one of them and suggest that everyone needs to be on the lookout for the possibility that things we assume may not hold true. And you have to step back from the paperwork of the transaction and ask yourself, am I protected? Is there anything I can do about this? And so right as we speak, advising a client that is not a studio, it's a producer, financier, self-financier of movies that has deals with different studios for distribution. And they have a deal for one of their properties, and it's with a studio that has an affiliated streaming service. And they're making a movie, and they're also working with the streaming service on a series based on the underlying IP or some version of it. And their conflicts have arisen. I'm just going to be very general about this, over release patterns and windows and what have you. And the streaming service is over here, and our client and the studio are over here. And the studio is unable to control its affiliated, wholly owned streaming service from doing what it wants to do. I've never encountered that before. I've seen rivalries where people are, they're publicly dissing one another, but I've not seen a situation, and the studio saying, sorry, we're not happy about it either. And that sounds like a lot of bull crap, but it's a very significant problem. It's creating ruptures in a lot of important planning, and well, just leave it at that. Keep it at a very high level. So if I'm looking at a transaction, and I would say to myself, look, am I counting on the fact that every party, that the studio is going to be aligned with the streaming service or what have you? It's like, don't assume anything.
Mm-hmm.
The only thing you can assume is that human nature is not going to change over the next year. It's probably not going to change in our lifetimes. And money talks and participant rights walk. And so, you've got to be looking for every form of chump insurance you can within the confines of the bargaining power that you have and the realities of wanting to close and all that sort of thing. But you really got to step back. And this is just not limited to affiliate related transactions. It's everything. And the other thing is, I don't know that I mean, you've got to assume the theatrical window or theatrical release concept of theatrical release, it's going to change. It's going to keep changing. Everything's going to change. And it's going to put pressures on people to make decisions that maybe they don't want to make, but they're going to make because it's the lesser of evils, and it's going to F your client if you know, in the process. That's the advice I'd give people is that it's not very specific, but if I'm looking at the agreement, you'll see things and you'll talk about them and see what you can do. But this is a very chaotic period. So there.
Wow, thank you. Chaotic is a powerful word, but it is probably, reflective of where we are. Um, what I wanted to do is I know we have a couple of minutes. I'm going to see if we can at least address a couple of the questions, and I'm going to just go in order. Well, one question I think we've already addressed regarding the imputed license fee. Another one, Chad, maybe you can speak to that, or any one of you. I don't believe that there have been any litigation or challenges to what we call alternative backend exhibits being suggested and by some of the studios to follow a model that's consistent with streamers. I don't believe that is something we've seen yet. I wanted to
Yeah,
confirm with you,
this is
Chad.
David Schraga's question.
Yeah,
Yeah. As you probably know, the litigation tends to lag behind deal making by a good 5 to 10 years. I mean, the deals that I'm litigating over were made, a while ago, up to a decade or more ago. So no, I haven't seen litigation about these new sort of alternative streaming backend just things yet because they're not being audited yet. But as soon as, or I mean, I don't know, or the audits haven't come across my desk yet, but it's coming and it's coming soon. And I mean, if there's any vehicle by which a distributor is paying money to participants based on success, that's exactly what we do. And that's, their vertical integration issues come into play there. If it's a self-dealing transaction,
right.
the valuation, whenever there's something to value. But as for my practice, I haven't dealt with those deals yet. And Netflix has been talking about it for years, and they still haven't done it. And now, recently Bell Bajaria said they're not going to do it. So I know other studios are starting to do some sort of payment for in success on streaming, but I haven't really. So it's coming down. It's coming down the pike. It's on the horizon, but I haven't really had a lot of experience with it yet.
Okay.
To your point
And
about Netflix, you're talking about doing it. One of the things I've noticed in some of their deal conversations lately is that they actually are asking for rights, off-platform rights. So just to flag that for some of the deal makers out there that, obviously if they're going to do that, they are at some time figuring that there could be a sub license from Netflix, and they are not presently offering any compensation, back end or otherwise, in exchange for that.
Wow.
Or
okay.
I'm seeing something right now like that with one of the key streaming platforms where they're paying a very substantial upfront fee. It's a rights acquisition, but they're reserving, and there's a back end, and we're talking about the value of the back end, and there's this reservation of off platform distribution, and but there's no clarity beyond that.
As to what it means, what it could be, and because the deal's in perpetuity, you're potentially giving away something very valuable that, arises in 20 years.
So can I throw out a crazy idea? I haven't really vetted this, so people are probably going to go, "Oh my God, what?" But having stuck my foot in it, quite often when we're litigating issues and we get to provisions in contracts and we say like, "Wow, that's an unusual provision," or whatever, and you want to say like, "Well, was there any discussion? Did you have any conversations?" Because lawyers and judges are looking to interpret contracts and understand what did the parties intend, what did they communicate to each other. Your undisclosed intent, subjective, is irrelevant. And we all live through email now. And so we're just firing markups back and forth. It would be so nice. It's dangerous, but think about it. It would be so nice if there was an email that says, like, look, I've redrafted this because I know our goal here is blank. And the nice thing about that is if the other side buys into it, then it makes it very hard for them to walk away from that language saying that's not what the parties intended. The risk is
Don't.
something you've now locked yourself into something, and there something may come up that nobody anticipated, and that makes it going to make it very hard for the lawyers to argue that it should be expanded to include that because no, the parties talked about it. It was only intended to cover this, and so double-edged sword. But sometimes people draft things so badly, and we just look at it and think like, well, if that's what they meant, it would have been so much easier to say this, and judges don't know what to do with that, and so you end up getting nothing. So anyway, crazy idea. There it is.
Well said. No, I know we've run out of time. There's a few more questions which our team together will look to address after the close of our webinar. But I really wanted to thank my three colleagues for taking time away from their schedule to be with me and really walk through some of these issues with everybody. Thank you, Ashley. Thank you, Chad. And thank you, Bobby. Appreciate
Thank
it.
you.
Thank you.
Thank
Thank you for
you.
having us.
Fun.
And
Hope
thanks
it was helpful.
everybody for joining.